any difference. I think you've had it a little longer, you just haven't had the opportunity to read it or haven't taken the opportunity.
Okay.
As long as you can make comments, I think I can
Sure.
also say them. I think we're here to schedule a hearing, since we can't have the actual hearing today, but to actually schedule a hearing for 312 hearings, so this can not just keep stopping. And I'd like our attorney for this issue to give us some idea of how this will proceed.
All right, if you, the purpose of this meeting is to decide if you're going to do a 312 hearing and on what matters you're going to do it, or if you're just not going to do it at all. That is completely within the council's discretion. What you would do is make a motion, there'd need to be a second, and you discuss, do you want to move forward with a 312 hearing or not? You can discuss kind of the base allegations regarding it. I can't really give you much in the way of legal advice that would conflict with my ethics rules in open session. But I put most of it into the writing, although sometimes I get a little complex when I'm writing on legal issues. So if there are questions, I apologize. We may not be able to answer them today, but if you want to move forward or you think you might want to move forward, then you can set a 312 hearing. We can still have an executive session prior to the 312 hearing if you wish. You can also give me instructions to go do something further, investigative-wise. But if you set the 312 hearing, I suggest you decide you're going to set one first with what subject matters would be included. And then you set the 312 hearing itself by a separate motion with a date, because you need to make sure you've talked about what is included in the 312 hearing. And then the report that I provided you today, it has attachments to it. One of the attachments is a recommended protocol to follow. My recommendation is you adopt the protocol basically for the protection of both Mr. Martinez and the complainants. It allows a fair, step-by-step process for conducting the 312 hearing if you have any questions. Now, it's up to you if you want to change things around or adjust it. Your charter notes that you must adopt rules of procedure. You have adopted rules of procedure by ordinance, but they're very generalized, and so that the protocols do not deviate from the rules of procedure you have already adopted. They just kind of supplement it. You don't have to do the third one, but I would recommend you do so just to make sure the process is efficient in the way that it's provided and everyone has their fair say in the way that it moves forward. So you would set it for a specific date, or you could give the city secretary or myself an instruction to coordinate for a date. But if you want to do that, I would set have a deadline of when if a date isn't set by a certain time, then you set a specific date, because we don't know exactly when Dr. Edwards may be able to return, and that can interfere with your timing. So it's up to you how you want to move forward with that, or if you decide you don't want to move forward at all, that is also up to you.
So how much do we talk about tonight? Minimally, I presume.
Yeah, tonight is really not about the substance of the complaints. It isn't about, he said, she said, he did this, she did that. It's about, do we want to have a hearing about it and have it discussed at the hearing? If you want to have a hearing about it, you can do so. You have a hearing. The hearing is termed as a hearing, but you also can conduct investigation during it. If there's anything else you want to add to it, you have the ability to. The only thing I would caution is if you're going to add anything, I have to provide Mr. Martinez a full list of charges that would be against him at the 312 hearing. So that's why I need you to just tell me what categories or what complaint elements you would want to consider, so I can make sure he is properly advised so he can prepare his statements in defense. That's a long-winded way of saying don't talk a lot and just decide if you want to have a hearing.
Okay, I would like to have a hearing because the charges that were brought, or complaints, I guess, not charges. The complaints that were made by 6 different individuals, and none of them, to my knowledge, have spoken publicly, and I've personally never spoken to any of them about their complaints. But at the last meeting, when we did have an executive session, Councilor Martinez was specifically directed not to talk prior to the termination of the executive session. And it's my understanding, and I heard from numerous people, that the moment we walked back there, he ran to the press to tell his side of the story and then began denigrating other people. And because of this, I think everybody should have a chance to tell his or her own story, and then a decision can be made. In effect, some people consider that we have a bully pulpit up here, and I don't like that consideration, and I think that we should not be using it as a bully pulpit. I think if nothing like this has ever occurred before, to my knowledge, at least not in my tenure, and we haven't had an opportunity to do this, we have kind of no clue how to proceed. But I do know that in any type of thing, you have a chance to say, and then you have a chance to respond, and then you have a chance to say again if it's necessary. We, unfortunately, have to be the judges of that. As I indicated before, we tried for weeks to get a date certain from Dr. Edwards. Repeatedly was asked by the city staff, and I understand even the mayor, to give us a date when he could be available, and that just never happened. So we're here tonight to try to pick a date. Hopefully it will work. I don't even know how to pick a date, but I do think we need to have a hearing.
Okay. Councilor Jordan.
Yes, I agree with Councilor Alcacer. We've attempted to address this matter way before now. I'm not for sure what the delay was before the unfortunate family incident. I'm praying for Dr. Edwards and his family. But however, allegations of sexual harassment and allegations of hostile work environment, allegations, potential violations of the city charter from a councilman are very serious. And I believe that the staff has to have an opportunity to be heard. We served at large, we represent the citizens of Leon Valley. So if we truly represent the citizens of Leon Valley, then we will represent the staff that takes care of the city of Leon Valley. So I think it's important that we proceed with this process after multiple attempts to have it heard when we had a full quorum. Thank you.
Okay. Let me address the difficulty in getting something scheduled with Dr. Edwards' schedule. And as I told you, Mr. Henry, when we started this, he works full-time. He's a full-time PhD psychologist. He does Social Security disability claims. He travels across the state. He's gone for a week at a time. And I told you when you and I talked, it was going to be very difficult to get something other than the city council meeting. He does his schedule, but he's always here for the council meetings. So that's the issue, and y'all know that. You know that he's out of town and he works. I mean, he's trying to make a living for his family. So please don't, consider that, because it's not because he doesn't want to be here. It's because he's got a commitment. And so now I don't know, with the situation with the family emergency, I don't know how that's going to affect his schedule. So, but let me just clarify, if the 312 hearing, if this is what these two counselors want to do, can go on just with them? You see what I'm saying? And without Dr. Edwards? Is that what you're telling me?
We could not
That
have
we
an
can just...
executive session.
We
but
can't
as
have an
long as-
executive, but we can have an open 312 hearing.
As long as one of the other two council members is present in the room.
Okay.
Yes.
All right. Very good. I have an issue with the 312 hearing as far as the procedure. And again, I'm relying on the Home Rule Charter, which I've learned to read and reread and read and reread. Under the hearing process for forfeiture of office and prohibitions, it says that a special meeting shall be called to hold the hearing. Well, let me just, the office holder, subject to any investigation in our hearing under the section, shall be entitled to written notice of allegations of forfeiture and/or alleged violations of this charter as applicable. Has that happened?
He's been provided several notices of what the original charges were, and information that has been provided to me going forward up until we encountered the executive session have been provided to him.
Okay, so he's gotten notice, is what you're telling me?
Yes.
On number
but
2.
We haven't started a 312 hearing yet, so the notice really isn't, it's not quite applicable.
So there's going to be another formal
There's going to be
notice?
another form.
Okay, that's
yeah,
what I
there's
wanted.
gonna be
That's what I want to clarify here. Okay, so he's been notified of some allegations, but not formally for the 312 hearing. Is
Right,
that what
because they
you're
haven't
saying?
decided that
Okay.
they're going to do a 312 hearing.
All right. all
Once
right.
they do,
Okay.
then I have to give him another set of notices.
Okay, all right. A member of the city council who initial, okay, that doesn't apply. But number 5, the city council shall means no if, buts, or maybe, in my book, adopt by ordinance rules of procedures to be followed. We've never done this before. We don't have a 312 hearing procedure in place. And by ordinance, to me, means that you have 2 readings. And I think you disagree with me on that. But I want to just put for the record that if we're going to have the 312 hearing, I feel very passionate that we need to follow the rules of the charter. We need to adopt protocol, which, Mr. Henry's taken the liberty to go ahead and do 3 pages of protocol, and the counselors can adopt that, but we still need 2 readings in order to make it an ordinance, is my read of the 312 process here.
Mayor, may I
You
respond?
may, because I know you and I have talked about it, and we disagree.
We disagree.
We
yes,
sure
yes.
do.
You actually have adopted ordinances in your code. They are just very sparse. You have a specific ordinance in, I believe it's chapter 1, that says for regular and special meetings, you shall be conducted under blah, blah, blah. But it's basically a 1-paragraph adoption of the procedures. And you guys have kind of moved along with your standard practices, which is fine to do. So I believe that ordinance, when adopted, qualifies as the minimum level that would be required under the charter, because it does list special meetings, and a 312 hearing is listed as a special meeting. However, because it is so sparse, I recommend you adopt some protocols for the meeting itself that are designed to help protect kind of both sides. I would recommend that in the future you adopt some ordinances just in case this does come up again, now that people are aware of it. But you've had the charter for a while, and it has not come up since then. But for a ordinance to be adopted, Mayor, you are correct. It must go through 2 readings. The protocols I'm suggesting are within the council's discretion for that particular meeting. They're not designed to be ordinance level types of things.
But again, our charter says by ordinance. And I think what you're referring to was pre-home rule charter, I think. Yeah, we just.
That I'm not sure.
Well, I
I'm
bet,
not sure.
because I'm just thinking that it's probably pre-home rule charter. So this is post-home rule charter. So, we haven't done a lot of ordinances that we're supposed to do according to the home rule charter. I mean, a lot. So that's all I'm saying, is that let's follow it. Let's follow the due process. I mean, this is very, very serious. We've never, ever had this before in the history of Leon Valley, an attempt to basically, I guess, undo an election and throw a sitting councilor off the dais is the ultimate sin.
That would be
here.
the ultimate
Yeah,
penalty.
exactly. Ultimate
They
penalty. I
can
mean, I
do
hope
less
that the
than that,
council doesn't
but-
do that, but
yeah.
that's why this is so serious, that we all know how we're going to conduct this 312 hearing, and especially the presiding officer.
Yes.
I mean, I don't, and to say that there's one paragraph that pertains, no. I think we've got to do it formally. So that's my 2 cents on that. But anyway, what would y'all like to say?
I have a
Or
question.
did you have anything else to
No, ma'am,
add?
we just
Okay.
disagree
I
on-
know,
on
we
the
do.
law.
Yeah.
Yes, sir.
I have a question for legal counsel. If it's the 312 hearing is ordered for tonight, then the hearing's not going to be tonight, number one, correct?
Yes, that's correct.
Okay, and then it's going to be set for a date certain or in the future. And by that time, you'll be able to craft specific guidelines on how to conduct the meeting, correct?
In attached
In
to-
accordance with the with the charter and our ordinances and so forth.
Attached to the report.
There's a
that I-
3-page, right?
Yeah, those are the crafting that I've done. Those are the protocols that I'm recommending that you actually impose by motion tonight. So you would move to adopt them for the 312 hearing, and then I have to give them to everybody so they know what the protocols are and they know what to do and prepare for the 312 hearing. That's my recommendation. Depending on when you set the 312 hearing. If you decide to set the 312 hearing for July, then yeah, we can probably adopt some ordinances by then. If you want to adopt the 312 hearing or set the 312 hearing, faster in the next couple of weeks, unless you have like special meetings back to back, there's no way you're going to get your ordinances drafted that fast. I don't know if you've ever done a rocket docket for passing ordinances very quickly. Lots of times citizens don't like it if you do it too fast. But it's up to you what you want to do for that. It is, depending on when you set the 312 hearing, you could probably do it by ordinance, but I don't think you need to. I think the way the ordinances are drafted, they meet the minimum requirements of the charter, and you can adopt the protocols to kind of supplement them for this specific meeting.
That's what I meant. Since the meeting's not tonight, then we have time to study those, and you'll be here to guide the presiding officer through the process at our next meeting, if it's 312 is ordered, correct?
Yes, sir. That would be correct.
Thank you.
I didn't know the term, but we actually did a rocket docket not so long ago, where we had so much on the agenda that we made 2 meetings just a few days apart, and so a couple of the things got the first reading at the first meeting, and a couple of days later. If you think that would be necessary, we could probably do that, and I'm not sure it would satisfy the mayor, but that certainly is a possibility if we need to adopt the protocol. If we don't,
I do not believe it is legally required for you to do it because you do have an ordinance, although I admit the ordinance is very sparse, which is why I'm recommending the protocols. If you feel it would be helpful for this one and stuff moving forward, it's up to you. If you want to try and schedule meetings back to back, very close to each other to give citizens time to see it, I'd recommend you just adopt what the protocols are, because I could change them because I actually listed names in there. But, that way everyone kind of knows what they are. You could set a 312 hearing and get meetings in between if you did 2 readings on it. And that's certainly within your purview to do if you want to do it that way.
and can you explain why it's important to not wait till July for this?
Well, yes. Some of the allegations qualify under what's called Title VII. I've given you recommendations on those, but the allegations basically trigger the requirement that an employer take prompt remedial action if such is necessary. If you're going to decide that such is necessary, you have to do it promptly. And the longer you wait, the more, or the less effective that legal defense is. So it also kind of depends. Part of it is contained within Councilwoman Rodriguez's complaints. If you would want to impose those or use those for interpretation for the charter. But either way, you want to make sure you're taking prompt remedial action in order to stay in line with what the legal standards are for those types of charges. It's up to you guys what you want to do and the timing. Now, the thing is, because Councilman Martinez is a council member, he is elected, that slows things down, just naturally, because only the council can take action on him. If he were a manager or employee or something like this would have been taken care of a long time ago. But the process gets slowed down just because he's on council, but it's supposed to be that way because he was elected. It's important for that process to be open and follow your protocols for your meetings and things like that. So I recommend it be prompt, but it's comparable given the particular situation. The complaints were originated in December, and we're now in April. And so the timing just kind of keeps getting stretched out and out.
Okay.
And
That was late December, and then we had the 2-week break, and then we came back in January. And that's when I met with you, was in January.
Yes,
so
ma'am.
That's really, I think
You met with me in January.
Yeah, so I think January is a fair month to, to really start the process because of the 2-week break.
Well, we received the complaints, I think it was like the 13th and 18th, or the 13th and 17th, something like that. But when they came in, I discussed it with the complainants at the time because there were only 2 at that time. Because of the holidays, it's difficult to initiate an investigation. And so they agreed that, as long as the investigation was going to initiate at the beginning of January, which it did, then they wouldn't have a problem with it. But that's when the other complaints came in. So you got January, February, March, and now we're in April. So we're at 4 months.
Okay.
I'm ready to make a motion. I move that we set a Section 312 hearing to investigate and consider all complaints against Councilor Benny Martinez that he improperly interfered with, gave orders to, and undermined the authority of, number 1, the legal department, i.e. the city attorney's office, number 2, the community development department, number 3, the city manager and or office and staff, number 4, the police department, and the complaint by Councilor Rodriguez.
A second.
Okay, so we'll have some discussion here before we take the vote. When are you going to give your recommendations from your investigation?
The investigation gets up to a point, and then it's turned over to the council. So my recommendations on the facts that are undisputed, which means everyone kind of agrees the facts, it's not a he said, she said, have been provided to the council. Anything related from that point forward, I don't comment on. It's up to the council to decide, like, factually
Are
what
we
happens.
able to say what you said in a 312 hearing?
In the three, well, yeah, you can say what I said
So
in
we
the
can
312
say
hearing.
what you concluded?
Not the legal advice,
No,
but
no,
the...
just the outcome of your investigation.
Yeah, the outcome of the investigation.
very
Yeah,
good.
because actually the entire investigation under the charter will be provided to the council at the 312 hearing. And so that
Okay,
will be included.
Right, and so we started
I
on...
know which sections you're talking about. Yes, those will be included.
So the hostile work environment and the alleged sexual harassment. But the giving orders, you and I have discussed that. That was not in the original complaints. And you said it's very thin, but that you're taking the charter globally, and so that you could add that. Is that correct? I just want
Not exactly,
I want to be
but-
sure that we're on the same page with that, because I have an objection to that.
Okay, so the first part of the retention to do the investigation was triggered under the city manager's authority when it was kind of required once she received her complaints. I perform the investigation. I provide council information that was discovered during the investigation. Two of the complaints listed violating the charter by kind of giving them orders or interfering, but that was not the focus of what those complaints were. Those complaints focused on other things. I provided the council information that was discovered during the investigation. At a 312 hearing, the council can investigate, it can examine, and it can have a hearing and decide on stuff. So if they want to include things that weren't under the, specifically listed in the complaint itself from the original ones, they're allowed to. I just have to make sure Mr. Martinez has notice of what those may be before the 312 hearing. And so if I'm understanding the motion correctly, that's for the departments, correct?
Yes, sir.
Okay. So the section you had mentioned before, Mayor, about making sure Mr. Martinez has a listing of what, the complaints against him that will be considered in the 312 hearing are, that will be provided to him based on Councilwoman Alcacer's motion.
All right, so, and again, we've had another disagreement about how the charter is interpreted, and that is that I agree with you that the city manager had the authority to be hired by you because it's personnel, with all the personnel.
So I think it was the reverse, for him to be hired by her, not her to be hired by
Oh,
you.
that's right, thank you. It's getting late. My brain is not working here. I'm trying. But you and I've talked. Councilor Martinez and Councilor Rodriguez are not employees.
That's correct.
And we have not, as a council, even decided that. We should, according to the charter, the 312, in general, to any other specific authority of investigation and hearing provided for in this charter, the city council shall have the power to inquire into the official conduct of any department, agency, appointed board, office, officers, employees. So,
That's
in
the
other words,
312 hearing.
yeah, that's the 312 hearing, but
Yeah.
I firmly believe that we should have, as a council, been notified of I was not notified of the complaint. It went right directly to to City Manager Kinsler. So, so you were hired to investigate everything and everyone. So who do you represent? The contract is with the city manager, but do you represent her and me and all of us
contract's with
and
the city.
everybody?
The contract's with the city. I represent the city as a body. I don't represent any one individual. I don't represent a department. I represent the city as a body. I answer to the city as a body. That's where my ethical obligation is, and that's where my retention is. My retention is technically divided for two parts, one being the factual investigation, which I provide the information because of your charter and the way your ordinances are drafted. She's the one that's in charge of all personnel matters. And so all that stuff goes to her, but because Councilman Martinez is a council member, she has no authority over him, so the only thing she can do is present it to council. Presenting it to council kind of triggers the next phase of my representation, because the city attorney has conflicted out because she is one of the complainants. She can't provide the council legal advice, so I was retained to provide the council legal advice basically in her stead for this subject only. And so my representation is always the city itself as an entity based on the way your charter and your ordinances are crafted.
But the council didn't take the council-to-council complaint.
I think that's what the motion just did.
But I mean, prior to this. So you were hired for the personnel, but yet you did it all. And that's what I'm saying, just the legality of it, you know, that we should have had authority from the council for you to proceed with the counselor-to-counselor complaint. Because, again, I'm looking at the taxpayer dollars. I don't know how much you've been incurred, but I know it's, you know, it's getting up there. Yeah, I mean, if you want to say, I don't know, but it's
don't recall off the top of my head.
Yeah, it's
But I'm
getting
sure
up
the numbers
there. So
are public record.
and we haven't ever, you know, authorized this expenditure yet. I know you and I've talked about that as well. So anyway, so these are just some of my concerns that, you know, complicated process. And we've never had a
Well,
charter before, so I'm not sure if I'm a
guys are
fan
fun.
of the charter.
You don't
know?
have the regular everyday thing.
What do you mean?
It is not something that comes up very often, and it is very complicated. And so providing the information globally up front, you know, on how to proceed with the way it was put together and what the council's options are for them to do next was the logical, and from the lawyer's standpoint, the ethical step, it's up to the council now to decide what it is they want to do. I think the motion actually says include all of it. The council-to-council allegation information was collected during the investigation, provided to council. They could decide to do what they want with it. It's completely up to them how they want to deal with it.
Well, but we unfortunately couldn't have the executive session to finalize the findings and then decide what's the best way to go. So I just feel like this is premature until we get a briefing from you on what you just gave us in a 30-page document. So,
Well, there are attachments. I think the
well,
pages
I know,
are
but
still.
still, it's a
I understand.
book,
I wish we
yeah.
could go into executive session too. I'm having to bite my tongue on the legal issues more. So
again, your firm legal advice is that we have a quorum.
yes,
We have two people
Yes.
that can set this hearing, two counselors who can set this hearing and go forth.
yes,
So,
ma'am.
all right. So we have a motion and a second to proceed with setting a 312 hearing on the various allegations against Mr. Martinez as per Counselor Alcacer. All those in favor say aye.
Aye.
Well, we're going to take B together. I mean, because
Yeah, 'cause
B,
the motion was
B was
together.
with Catherine Rodriguez. So if the council will allow me, 5.A and B is your motion here to take all of the complaints together. So if that's appropriate, right? All right. So all those in favor say aye.
Aye.
Any opposed? The motion does carry 2-4, and nobody else is here. So, all right, thank you. We have citizens to be heard, so I do.
Well, I think
I
there's
have a
some more
couple of
motions.
more motions.
Oh, you have
Mayor.
more motions?
Yes, ma'am.
Oh, wow.
Well, I
That's news
suggested
to
they set it, and you know they decide to set on what, and then they need to set a date.
Oh, okay, sorry.
And so
Sorry about that.
That's the next motion.
Okay, did not realize that.
I move that we set the hearing on or before April 30th, 2019. If the, Sandra, I'm going to throw the burden at you. If you and the attorney are not able to coordinate a date before April 30th, then I am moving that the ultimate date be 30th at 6 PM. We need anything else, sir?
You need a
A
second.
second.
Okay.
And
And my discussion is I object because we don't have an ordinance in place, and we need 2 hearings to adopt the rules of protocol for a 312 hearing, and I respectfully disagree that we already have it in our prior ordinances. So just for the record. So April 30th at 6 PM here to conduct the hearing. All those in favor say aye.
Aye.
Any opposed? The motion does carry 2 ayes and nobody else is here. All right,
Mayor, I
anything
did
else?
recommend whether or not the council wants to adopt the protocols or not. It's up to them if they want to do that, or they want to try and pass it by ordinance, or they just don't want to do it at all. Again, it's up to them.
Okay, well,
I'll make a motion, we adopt the suggested protocols as written up by Mr. Henry in reference to the guidelines on how to conduct this 312 hearing, and all inclusive of what his instructions were in the 3-page document.
and can I add a little addition to that for your motion?
Okay.
That the protocols be circulated to all the complainants, the city manager, the city secretary, and Councilor Martinez before the 312 hearing. Is that acceptable?
Yes, ma'am.
I second.
All right, adopt suggested protocols for the 312 hearing as per Mr. Henry. There's 3 pages in our 30-page document that we just got, and circulate it to everyone. A motion and a second. Again, I firmly believe that these protocols need to be adopted by ordinance, which is a 2-step hearing. And so I'll just put that on the record as well. So all those in favor say aye.
Aye.
Any opposed? The motion does carry. Anything else?
No, unless you want to have
Well, we've got citizens to be heard. I'd like to hear. Huh?
unless you want to
No, we're not-
schedule a hearing right now first.
No,
I
not
mean,
really.
not a hearing.
No.
Ma'am, let me talk.
Go ahead.
Schedule 2 meetings to get this adopted before. Would that satisfy you, before the 30th?
I don't know if we have enough time, but we can
We
try.
always have time when we need it.
Okay,
So-
well, we'll look at that if that's something but that wasn't in your motion, so that's why I just wanted to make sure that my objection was that we need 2 hearings. Okay, citizens to be heard. Anyone from the audience that would like to address the council, please come forward.
Benny Martinez.
Excuse me, I have a question. Can Mr. Martinez speak from the floor at this particular point in the process?
My legal recommendation is that he doesn't, there are problems when a member of the body goes on and speaks as a citizen. But it actually is at the discretion of the presiding member if she wants to allow it. But I recommend that to protect Mr. Martinez, and if Councilwoman Rodriguez had wanted to get up and speak, I would recommend not to protect her as well. But I would go ahead and defer to the presiding officer's discretion on that one.
That was the nature of my concern, is due to the fact that Mr. Martinez is named in the process.
Yeah.
Is he allowed to speak?
Well, the charter actually says he cannot deliberate or vote. If he's going to be presenting information on it, it can be interpreted as a deliberation because he's providing information to the body outside of the 312 hearing. He subjects himself to problems. If he does that, it's really not a problem for the body. It's not a problem for you guys. It's a problem for them. Because a deliberation is an exchange of information and ideas. And so even if a body stays silent while it receives information, that is interpreted by the AG's office to be deliberation. So It is strongly recommended that it not be allowed because it constitutes deliberation under the open meetings, and your charter prohibits that.
I have additional question.
Yes, sir.
Don't the rest of the staff or whoever comes up to testify during the 312 hearing, don't they have to be sworn in under oath?
At the 312 hearing, they do, and so I would recommend that actually none of the complainants really talk now. You want to swear them under oath because they're providing information to you that you would essentially have to disregard until they are there and placed under oath. So, but Mr. Martinez, if he's stepping up now, is also not under oath.
Right, I understand that. I'm not suggesting he be put under oath here
Yes.
just because it's a citizen's behavior. What I'm saying is anybody else that gets up and speaks is subject to be sworn in under oath, and therefore the statements that they made, so forth. So
At the 312 hearing, yes,
right,
sir.
at the 312 hearing.
Yes, sir.
So I would like to request, Madam Mayor, that Mr. Martinez not be allowed to speak to protect himself as well as the process that we have coming up
Okay.
in the future.
I'm going to ask Mr. Martinez. Mr. Martinez, you've heard the discussion. Mr. Henry's trying to protect you from, I guess, harming you for the next hearing. And so do you want to consider just saving that and for the 312 hearing, your statement, whatever you wanted to read? I don't know what it is, but.
My statement does not have any factual, what little I have received of the allegations against me, that packet that you just gave to the mayor, I have not received that. So all I have is a couple correspondence of the allegations against me. So I am unclear of what other thing I can say. And my statement does not address any, mention any of the complainants against me or anything to do with them. So with that, I'd like to continue with my statement.
If
I'm
it's on the
following the
subject
same,
matter.
I'm following the same guidance that you mentioned. You have to bite your tongue and not, go overboard. So
what
I
were
am
you
doing
gonna
the same
say?
thing.
He has another comment.
The charter says deliberation. That's deliberation on any subject, not just the factual basis of it. Again, that's what the charter prohibits. If you move forward, that could be used against you in the 312 hearing. You just need to be aware of that.
I am aware of that. But one of the questions I have, what's the urgency in this? Why? Election. That's it, the election. Is that why the rush to get this done by the 30th? But I would like to make my statement.
Okay. Mr. Martinez, I just want to make, because I'm a huge proponent on hearing from people, as you know. I mean, that our local rules permit it, anybody to speak at any agenda item, but I just want to caution you what Mr. Henry just said, that I don't want, I mean, what you say today could be used against you, so if you still want to go forth with it, that's up to you, but.
And no one's saying you can't say what you want to say at the 312 hearing.
And
That's the place for it. It's just you don't want to have the deliberation element brought into it.
I would also ask the mayor to caution the audience. We have one person in particular already shouting out things, and it's very inappropriate.
Okay, thank you. Yeah, if you have something to say, I really want to hear from you, but if you'll come up to the podium and state your name and where you live, we'll do it that way. But thank you very much, Ms. Alcacer, for that. Okay, so Mr. Martinez, it's up to you.
I'd like to continue with my
precaution.
statement.
Now, you have 5 minutes.
I
and
doubt
I'm going
if
to
it'll
keep you to the limit.
Okay, I
of
doubt
5
it will
minutes.
take me that long.
Okay.
I, Benny Martinez, wish to make this statement regarding the allegations against me. I wholeheartedly disagree and deny all allegations. First and foremost, I believe all the actions against me are a calculated and vicious attack by the city manager, Kelly Kinsler. This witch hunt is similar to the attack that the city manager did about 18 months ago against the chair of the zoning commission who disagreed with her. City council found he did nothing wrong, but decided to resign to remove the burden from the zoning commission. He is currently still under criminal investigation by the chief of police to keep him from demanding documents about this bogus allegation under the Public Information Act. On April 2nd, I filed a formal complaint against the city manager because Kelly Kinsler constantly acts like she is the city manager, mayor, and city council rolled into one. This complaint must be dealt with by the city council. Tonight, we had an amended city council agenda item relating to the multi-million-dollar contract for red light cameras. The city manager signed this contract without the mayor or city council approval. This is a gross violation of her duties. This is at least the second time the city manager has acted on a policy matter without council authorization. During the April 2nd city council meeting, Mr. Henry, attorney for the city, shut me down and refused to allow me to finish my statement. The city manager was making gestures to Mr. Henry, who was out in the audience, by moving her finger across her throat. Mr. Henry got up and interrupted my statement. At this point, Mr. Henry was a spectator in the audience and had no legal right or justification to interrupt a city council member. Mr. Henry has continued to bill the city, and it is estimated his bill is around $25,000. Neither his hiring nor his bill have been considered or approved by city council. In order to remain impartial, why would city council member Alcazar contact Mr. Henry after his report was completed? Last year, David Jordan sent me a very nasty email complaining about a question I asked of our police chief on an ordinance. He further questioned me about my statement Crystal Caldera made about spending $1,900 a year on web hosting. GoDaddy premium plan is $300 a year. I believe I was just being fiscally conservative. With these facts, I do not believe the City Council is in a position to continue with this investigation against me. Mr. Henry's report states most of the claims do not have any merit. If there's going to be a public hearing on any of these false complaints, I demand a procedural ordinance be passed as required by the Charter, which allows me due process of law, including a clear statement of the legal and factual basis of the actions and time to hire an attorney and to prepare a proper defense. I don't know if I can hire an attorney and have an attorney brought up to speed before the end of the month.
Okay, thank you, Mr. Martinez. All right, yes.
My name is Will Bradshaw, and I live in Monte Robles, and I am running for Leon Valley City Council, Place 5, the election coming up on May 4th. And I think it's very obvious what you're doing up there, and I think it's disgraceful and shameful that you are targeting Mr. Martinez like this. And it's very obvious the split on the council with all these issues. They're consistently voted a certain way, and it's just embarrassing. It's embarrassing to our city, and it's embarrassing that people would stoop so low to come up with these allegations.
Thank you. Ms. Chasen?
Tina
Yes.
Chasen, Forest Oaks. First of all, I'd like to clear something up. Ms. Alcar, you said wrongly that at the last council meeting when you went into executive session that Mr. Martinez ran to give an interview. I was sitting right there. They approached him. He was talking with us. They approached him. So that was wrong, and I want that noted. Second of all, I've known Mr. Martinez for years, and one of the things that I respect so highly about him is that without bias, he will be intense in his questioning of everyone that comes before the council and everything that they bring before the council. I've never seen anybody be so intense to elicit the truth and get to the basis of it. He listens, and then he makes his own decision. Third, I agree with the mayor. I don't believe that Attorney Henry should have the right to set any of the ordinances. I'm on several committees. I'm actively involved in a lot of areas of the city. We have the right, under home rule, independent city that we are, to make our ordinances, and not anybody else coming in from the outside. Thank you.
I'm Pat Martinez. Benny is my husband. And on that remark you said a while ago that this is fun, you don't usually have this happen, I think that's a disgraceful remark, and I do not accept that. It is not fun.
Council members, I just feel very embarrassed for the city, for all of us. This is airing laundry and allegations that have just run rampant now. I don't see why you're dragging the city down with these allegations just to go after one person. And I honestly don't believe a lot of the allegations I've read. They're very fictitious sounding. And I'm really sorry that you're doing this to the city. You're here to help the city, and I don't think that this is helping it by just, now we've got to spend time and money doing this, hiring attorneys, dredging up stuff that happened 2 years ago that have now is not true. They have added on additional things to their statements, to their depositions, and I just don't think it's a waste of money. And I'm sorry y'all feel that way, that you have to be so, and you're always talking, Monica, about be nice to people. You are not nice. You sit there and tell the mayor, you got it sooner than that. Do you think that's appropriate on the air? I don't. You should keep that comment outside. And I still question that you told me that you are working in Dilley as an employee, and to be on the city council, that is not a conflict of interest. I believe it is. You have missed several city council meetings because you were dealing with issues in Dilley. So I think you need to choose one or the other, or step down. I'm sorry. Thank you.
Darby Ronnie. This looks like an open meetings violation. The two council people clearly have agreed on the entire matter in advance weeks ago. And it looks like the hearing is really just a pro forma matter that you've already got your minds made up. And it's clearly so political, it's an outrage, a terrible abuse of this new charter. We've definitely got to repeal Article 3, because this is a terrible abuse of our political system around here. It was orchestrated by the staff and with the cooperation of the two council people, and it's not going to work. I'll predict.
I'm Donna Charles, and I live in Shadow Mist. I just want to clarify something, at least to my thinking. Everybody was talking to the counselors like it was their charges. It really wasn't the charges of the council. It was staff charges or allegations. And so they're just in a position to have to act upon that. And I wouldn't mention anybody missing council meetings. Dr. Edwards has missed a lot.
I'm Irene Baldridge, and I live on Parsley Hill in Leon Valley. I am just shocked and astounded how we can treat each other like we're treating each other. I know no one is perfect. All of us are trying to do the best we can, the way we can do it. And why can't we logically work together and get things the way we have been, to let this city go with an outstanding record and not have this underground turmoil that's not going to stay local, it's going to be spread. And do we feel comfortable with this? I don't. And I hope that you can decide what's best for all. Thank you.
Maria Gamboa, Forest Meadow. My question, probably Mr. Henry, for you, is if he isn't an employee and the allegations are here, why wouldn't the city manager, before approaching you with the investigation, go investigate, right? Why didn't he inform the mayor? That's my question.
Anyone else?
Do you wish me to answer, Mayor? Do you wish me to answer?
Sure, go right ahead. I mean, it's been an open process.
All right.
Go right ahead, yeah.
Well, different cities do it different ways, and so unless I get...
You know,
Okay.
we used to have real strict rules on you can't speak, you can't speak, you can't speak many, many years ago. I've been here too long, you know, not too long, but I've been here long. And so I value the opportunity to have a dialogue and speak in a respectful manner, which we've done. And I thank everyone that's come and spoken. I think everybody's been very respectful in the process. It's very difficult.
The personnel policy procedures that are in place note that the mayor must be informed for employees, not council member matters, but employees. The city manager went to her city attorney to ask what to do, and the city attorney was conflicted out. So she didn't have any guidance to figure out what to do. She can probably expand better if she wants to chime in. I know what I've been told, which is she consulted, you guys are a member of the TML, the league, so you can call and ask for general questions. She did, and they said get an outside legal counsel as soon as you can to help advise you. And so that's what she did. I believe that answers the question. I don't want to go into too many more details because that actually circles into some of the attorney-client privilege parts and the chronology and timing. But I believe that answers the question.
Okay. Oops. Your time is up. I'm just teasing. You sure may. You may, Maria. Go right ahead.
If that's the reason, wouldn't you have advised her once she spoke to you to go speak to her mayor?
I can't tell you what I would advise her or can't advise her. That's the attorney-client privilege part.
Interesting.
Mm-hmm. Yeah, okay. We're not going to, no other comments unless you come up to the podium, but thank you. But we can speak later. So, yes.
Will Bradshaw, earlier you said you work for the city as a body. So then again, you're talking about attorney-client privilege, but you're acting like the city manager is your client.
Releasing attorney-client privilege into the public is not what I'm permitted to do. That's why there's an executive session.
If that's the city...
Please let me finish, sir.
Okay.
I'm not permitted to actually release attorney-client privileged information into the public. I advise the body as a whole. That's why it's set for executive session. I would prefer we be in there so I can answer questions. I don't answer questions to the public. I answer questions of the body. And so that is where my ethical duty lies.
So part of the body knew that you were being, giving advice and being hired, but the other part of the body did not. Meaning, Ms. Kensler hired you and told you this information, but the mayor and the rest of the city council was in the dark during this time.
We won't get into yeah. Anyway. Okay. Anything else?
I believe Mr.
yes.
Jordan has.
Madam Mayor, am I allowed to speak?
You certainly are. I'm sorry, I didn't see your hand up.
Okay, no problem. I just simply want to say this. These accusations came to us as city councilors by the city staff and two of our fellow city councilors, myself, Ms. Alcacer, the mayor, had nothing to do with this situation. However, due to the situation and the people that are involved in the process, we are the ones that's left to make the decisions. So, number one, I'm a man of integrity, and I'm not going to sit and take an accusation that's not true. This came to us. We didn't come to them, okay? The people that are involved in the process were eliminated because of their positions. This leaves us to make the decisions. So, we have been trying to get this process started a long time. A long time. We have repeatedly requested a meeting, repeatedly requested a meeting, repeatedly requested a meeting. So to, sit up and say, oh, it's because of the election, this has been going on for months. We kept it to ourselves for respect of all the parties involved. So no sir and no ma'am. David Jordan had nothing to do with it. Monica Alcacer had nothing to do with it. Mayor Riley had nothing to do with it. These were allegations that were brought to us. I take them very seriously. The staff has a right to be heard. Mr. Martinez has a right for his to be heard, and that's what we're trying to do, fair and equal across the board. That's the facts, and I want that on the record as the facts.
Okay, thank you.
Mayor, I may be able to clear up something, especially for you, ma'am. I think I can answer your question easily. So everything that Mr. Henry said, I agree with. The only thing that really got left out is as soon as I was advised to hire Mr. Henry for a pre-litigation investigation, that's exactly what I did, and I notified the mayor immediately. So the mayor and I knew what was going on, but there was reasons that the rest of the council didn't know that I guess would be disclosed later. But I did not have this knowledge alone. I went to our legal counsel, which at TML, since our attorney was conflicted out, and asked, I wanted to ensure that I was doing the right things, because right now, what my concern is any liability on the city, on the council, on Mr. Martinez. I wanted to make sure that everybody was taken care of, the citizens as a whole. I'm not responsible to Councilor Jordan or Councilor Martinez. I'm responsible to the entire council and the entire citizenry. And so I can't think in terms like that. I have to think in terms of the whole body. And that was really important to me, to make certain that the liability was limited to the best of my ability, and that I took the advice of our insurance carrier, and who is also our legal counsel at the Texas Municipal League, who referred me to Mr. Henry, and said that, actually they gave me a list of names, but the first two we already had cases with. So the third name was Mr. Henry, and the first time I met Mr. Henry was at the last council meeting when he appeared. I've never even met him, just so you know that. I think maybe that helps clarify a little bit better. Just trying to clarify for you, because I could see that you were a little off.
It's like when something happens, right? I mean, she's in charge. Look, I'm thinking that way, that she's in charge because all of y'all are here together. And you would go to her and say, hey, look, I found this out. And then you would do what you've done. That's the only question that I have.
Right.
Because, I mean, this is what I saw in my brain. I'm listening to everything that everybody's saying. I don't have a pro or a con for anybody.
Right.
But I'm listening to what y'all are saying, and I'm getting these questions in my mind. And that was one of them, because, I mean, it's just like a mother and kid, you know.
I think it's an
You got to
excellent-
come to me when something's happening, right?
I think it's an excellent.
That was my point.
I think it's an excellent question, and I took the advice of our insured and our attorney from the Texas Municipal League. Excuse me. I just wanted to follow back up because there was a question and I allowed you to answer it, so I'm going to follow back up. I was informed after the fact. Ms. Kinsler had already called the insurance company. And if I had it to do it all over again, because it's the counselor in me that says, man, if we could have sat down, brought everybody together, worked this out, maybe even hired a mediator to mediate the problem, then we wouldn't be here today. And that's my regret, number one. Number two, prior to the Home Rule Charter, and I can tell you at least 3 occasions where if there was a dispute with another counselor, the route you went was you filed a lawsuit. That's what you did. It was outside the city because we didn't have the charter. And so, again, the citizens are bearing the cost of this 312 hearing. And we got to ask ourselves, maybe there's a different way we could handle it next time, because I think it's like Mrs. Baldridge, that was the most beautiful statement, because I've been torn up as well. I can't sleep. I can't believe our city is just imploding on itself, and we're all fighting and can't get. I mean, it's just, I don't know. It's really, I'm very sad. I've never seen this in 15 years as your mayor. So, with that said. Yeah, I can tell you, when somebody comes to you as a city manager with a 1986 a civil rights violation, you don't mediate that away. You investigate it. You take responsibility and you make sure that not only are your complainants protected, but the accused is protected as well. We want everybody protected. And so mediation is a wonderful thing, and I always agree with mediation, but not for when somebody has a 1986 violation. And that is why I felt like I needed legal advice from the Texas Municipal League, and I obtained it. And I followed it.
Okay. Yes, because we're about ready to close this Citizens Be Heard.
I think there were like 6 complaints against Benny. It seemed kind of strange that they all kind of just gathered up in one pile at the end of the year. One of those complaints is from something that happened almost 2 years ago. If there was something wrong then, why didn't they come forward then? So, I just think it's strange that they just one right after the other, just like it was planned.
I have just one comment to make, and nothing to do with this. I am a technology professional. What did I do tonight? Did I help get this thing working?
Okay. All right. Anything else, Ms. Alcacer? I think you want to go home and see the Spurs game. So does everybody else, right? All right. Thank you all for your comments. And if there's no objection, at 9:58, I will move for adjournment of the Leon Valley City Council special meeting.